If you're about to start this journey or if you're in the middle of it, good luck. Things will definitely get better. Keep the spirit up and come out the other end as a happy person. Hello and welcome to my video about self-representing in family court proceedings, specifically in proceedings for child arrangement orders. You may be at the start of that journey or in the middle of it, and you are wondering whether you should seek legal advice or potentially self-represent. I'm a believer that it doesn't need to be either or. You can also mix and match. And you might be wondering, why would someone want to self-represent? And the reason is either you're looking to save a lot of money. Legal representation is very expensive. If you are married with someone, you might have a number of court proceedings ranging from divorce, financial remedy, child arrangements, prohibited steps, specific issues order. And if there's 5 of them, you might need to file applications for each one individually, and you might be charged £600 or £800. And then there's also a charge per email as well, which can be between £100 and £200. And therefore, it's not that difficult to spend £50,000 on a divorce or even £100,000. And there's also cases there where couples have spent 18 years worth of life savings on legal fees. And I also read about a case where parents had spent £5 million on court proceedings. So it can be extremely expensive, but it's not just about saving money, but another reason why you might want to self-represent or learn about self-representation. And that is because you may want to learn more about how the family court system works. And therefore, even if you have legal advice, you feel more confident during the proceedings, because even if you have solicitors or barristers, there are certain things that they will not do for you. They will, for example, not tell you what to write in your statements or how to write your statements and what words or languages to use. And that is where it's beneficial to do some research yourself and get a good understanding of how the family court works and how judges make decisions, how they establish facts, how they determine allegations, and how they determine whether allegations are relevant to the future arrangements for a child. One of the landmark moments in the family court process is applying for child arrangement orders or being served with the other party's application for child arrangement orders. It's a nerve-wracking moment during which you realize that you are no longer a couple, but that you two entities. And you might feel emotions such as anxiety, sadness, rage, or even depression. But rest assured, some of these emotions will subside with time. And it can also be incredibly difficult to read things written by the other party that you might not agree with, or in some cases it could be things that are true but you don't enjoy reading about it. After all, we humans aren't really accustomed to receiving feedback, and it can be something that's difficult to actually read, and you will receive a lot of feedback during the family court process. So when you propose child arrangements to the court, you should illustrate them very clearly, ideally in a bullet pointed form, not just to the court, but also to the other party. So that can include child arrangements for term time, half terms, summer holidays, Christmas, birthdays, and also any major milestones. The arrangements that you propose will likely look different depending on what your lifestyle is and also the age of your child as well. So the child arrangement for a newborn could look completely different to those for a child who's just about to start school. And therefore, for someone like a newborn, the arrangement could include laddering of contact to say, hey, in the first 6 months, these are the number of hours that the other parent is going to see the child, and it's going to go up by X amount to then overnights, then for example extended weekends. So do consider laddering as well, because after all, the arrangements need to be practical and also age appropriate. You also need to then you also need to explain why you believe those arrangements are in a child's best interest. And it could be that you don't currently have contact with the child, but it could also be that you have contact with the child, but circumstances have changed. For example, you have child arrangements that are out of date, or you might have moved closer to a child's school, or your job has changed to now enable you to spend more time with the child. So try to explain why you believe those arrangements are in the child's best interest. And bear in mind that the court doesn't know anything about you and your child, and they can't assume anything either. All families are different, so therefore you should also give a brief background on the relationship between you and your child. What are the current arrangements? Do you see the child every day? Do you live in the same house? Do you do school runs? Do you spend extended time over the weekend? Have you been in the child's life since birth? Give a little bit of a background, and this is background that not just the court will read, but also other parties that might be consulted during the proceedings for your case. So try to bullet point them as briefly as possible. And this is also a good exercise for getting used to writing, because writing is the most powerful tool during the court process, because it's a long process and one that might involve having to recall events that happened 3 years ago, 5 years ago, or 10 years ago, and having everything down written on a paper will give you a lot more confidence during hearings, especially hearings that are as short as 20 minutes long. During those, you will not really have any time to give a 30-minute monologue, and you necessarily don't want to leave a hearing thinking that the judge made the wrong decision based on things that you know, but that you haven't shared. So try to put as much down on paper as possible. Usually the court will state what the page limit is. So do factor that in, but do use your statement as an opportunity to put down as much as possible. And you may also have concerns for yourself or the child, whether they are emotional concerns, physical or financial concerns that might be related to abuse. Put them down in the statement as well. And when you do so, try to list them chronologically as incidents. And with each incident, you may want to highlight what happened, who was there, what happened in the lead up to that incident, and also what happened afterwards. So what was the action? Who was the victim? What was the impact on the victim in the form of abuse, whether it's emotional, psychological, and physical, etc. And how did the victim feel? So try to spell everything out as clearly as possible. However, do bear in mind that child arrangement orders is a proceeding which the court is focused on looking ahead and putting together arrangements for the child's future, and that those arrangements are safe and in the child's interest, rather than looking back and try to put together a points tally of which parent is the nicer person, who was mostly in the wrong, or who's responsible for the breakup of the relationship. That's not the focus of child arrangement order. So therefore, try to make your statement as relevant to that as possible. And if the abuse is related to yourself, that could also be included there, especially if a child has witnessed that abuse. And then it's up to the court to read those allegations and make directions for that. And ultimately, everyone has the right to be heard. We live in a democratic country, so don't feel wrong or nervous about putting something down that you are unsure of. You will not be penalized for that. In family court proceedings, facts carry heavy weighting in decision making. Therefore, where possible, you should support your statements with evidence, and the evidence should ideally be in the appendix, and that should contain exhibits, which is named for different pieces of evidence. So one exhibit could be a photo, and the other one could be text messages, and the others could even be a letter from a GP or from a child's school. So try to include it where possible, because this also minimizes any risk of the other person disputing what actually happens, and it also serves as a factual point and insight that essentially speaks for itself, rather than you having to rely on he said, she said. However, this does not mean that you shouldn't include things that don't have any evidence, because it's still important to be heard. And in family court, allegations are proven if the judge believes there's a 50% probability that something may have happened. So it's not like criminal court where an allegation is generally only proven if it's beyond reasonable doubt. And therefore, in the family court proceedings, like even if you don't have evidence for a particular incident, it's still worthwhile to put it down in your statement. This brings us to the question of what is a fact? And this is where things can get very complicated and very nuanced. And court proceedings can be a bit of a war on words. So you have to be very mindful about how you describe things, and try to describe things to the court in a neutral way as possible. And then let the judge or court make a judgment on what actually happened, or how to categorize a specific incident. So you might write a statement and say, there was an argument. What is an argument? And an argument can be quite a loaded word. Someone who hears the word argument, that they might think that, there must have been screaming or shouting and potentially some violence. But you can use other words and say that there was a discussion, or we had a debate, or we had a disagreement. So be careful about using emotionally loaded words. And also, how does the judge or court prove a fact? One of the most obvious way that they prove a fact is if two people agree on something. So I can say, yesterday I drank an orange juice. And then you might say, no, you did not. And then the judge would think, okay, that is something that we need to have a fact finding for, because we don't know whether I drank a glass of orange juice or not. But if you say, yes, he drank a glass of orange juice, then that almost becomes a fact. It means that, hey, he drank a glass of orange juice. Now that's a fact. That's a fact that we would then base decisions on. But it gets a little bit more complicated with allegations. So with allegations, they tend to be focused on something that's written in the book of law, either allegation of physical abuse, financial abuse, and lots of other ones as well. So it always links back to what's written in the law book. So let's create a really good example. So I might be accused of stealing a bracelet in a shop. So the facts were, I was in a shop, I was holding a bracelet, I received a phone call, the reception was a little bit poor, so I haphazardly walked out of the store but with the actual bracelet in hand. And I kept speaking on the phone, and then I eventually walked away and didn't come back into the store that day. You might say that's theft, but whether or not it's theft tend to depend on what happened before the incident and also what happened afterwards. So let's say, for example, the following day, I then realized that, wow, I left the store with this bracelet. It's mine and it's not been paid for. And I then go back and either pay for the bracelet or return it. Then it wasn't really theft. But if I keep the bracelet and then brag to a friend on text to say that, hey, I accidentally left the store with the bracelet, then that is theft. So this is an example of how decisions can be made, not just based on what blatantly happened, but also what happened before and afterwards as well. And in the context of family court proceedings, the court always looks at intent. Was there an intent to harm? Is this a one-off incident, or is there a pattern of a behavior repeating itself? And is the person showing any understanding, any insight or remorse for their actions? And are they willing to learn from those experiences and not repeat them? So those are the things that the court takes into consideration. So those are examples of things that the court takes into consideration. They're not there to penalize parents, but they're there to help parents, but they're there to educate. They are there to educate the parents on how to create a safe environment for the child to flourish in. If there are facts that are heavily disputed between both parties, the court might need expert witness to help, and this could be schools, psychologists, and any other third party, but the court might also require a fact-finding hearing. And a fact-finding hearing is specifically after statements have been served to both parties and submitted to the court. The next step is a direction hearing, or so-called first hearing. And as the name suggests, it's a hearing to decide the direction that the court application should take in order to resolve some of the issues that are stated. And it will be the court's job to summarize all the issues using both the statements, and they will also then speak to you in the first hearing to kind of see whether any of those have been resolved. So one of them could be that either of you have a potentially dangerous dog, but that's an issue that might have been solved because the dog is no longer with you. So the court would just go through them all one by one, and you might also have been able to agree on arrangements for Christmas, so therefore that's no longer an issue. And they will go through each one by one and then tell you both what the next steps might be. And you will also have an opportunities to basically say whether you agree with the court or not on the next steps. Before the hearing, the court will have expected both parties to have spoken to see whether they can come to an agreement on child arrangements, because as parents, you know the children or the child much better than the court, and they believe that where possible, parents should be the ones to propose child arrangements. And then before the first hearing, the court will expect you to both. Before the first hearing, the court will expect both parties to speak to see if they can come to an agreement on child arrangements, or alternatively narrow down the list of things that they disagree on. And therefore you are likely to speak to the other party's barrister if they have one, probably on the day of the hearing or a day before. But there may also be a few email exchanges beforehand with a couple of proposals. But bear in mind that you're not legally obliged to agree to any of the proposals if you genuinely believe that they're not in the best interest of a child. So therefore, don't feel pressured to agree to anything that you don't believe is right for a child, or something where you feel like you maybe need a third opinion on from the court. So there will likely be an exchange. And at the start of the hearing, the court will ask exactly about that, whether both parties have spoken, and you will essentially give a summary of that. If the other person has a barrister, then they will be the one providing the summary to the court. And also during the hearing, the court will then try to summarize all the issues that you don't agree on, because before the hearing, they will have spent quite a bit of time reading all the statements and then being ready to just like summarize them all and then propose the next steps. The next steps could range from a safeguarding check by Cafcass to psychological tests, to maybe blood tests if there's allegations of substance abuse, and there's lots of other steps depending on the circumstances of. The next steps for your case can greatly vary depending on how simple or how complex your case is. And this will really be determined on the number of different parties involved, whether there's police involved because there's been a application made for criminal activity, or if there's local authority involved, guardians, and other family members potentially. But it can also, next steps could also involve things such as a Cafcass safeguarding check, or the court might even order both parents to speak to a psychologist, and there can even be a blood test if there's allegation of substance abuse. So it can greatly vary. And if there is a situation where there are allegations of abuse and there's a couple of very important incidents that are disputed, then the court might order a fact-finding hearing to take place before they decide on the future arrangements for a child. Some of these next steps could take 3 months to complete. Some could take 2 months, others 6 months, or other 8 months, or even 12 months. Like some family court proceedings, they take like 12 months to complete, or even 24 or 36. So it's difficult to say how long things will take and what steps might come in where. And there could also be a case where you even have 2 direction hearings. If the child has a relationship with both parents, the first direction hearing can also be used to try to agree interim arrangements that will allow a child to still see both parents during the court proceedings. And whether interim arrangements are ordered or not really depends on who sits the hearing. There are judges, there are legal advisors with the lay magistrate, and then there are just legal advisors. The highest level is a judge. And judges have the power to make interim arrangements where both parents disagree. However, legal advisors with lay magistrates, they also have similar powers, but they are a lot more risk averse than judges, and they tend to be very conservative in the interim recommendations that they put forward. Because they also don't have the same experiences, judges, and they haven't had the same legal training either. And then you have legal advisors, and their powers are restricted to writing legal documents where both parties agree. So therefore, if one parent currently has the kids and say, hey, this is my offer for the other parent, take it or leave it. Then if legal advisors are sitting your hearing, then you might have no option but to accept that proposal. Bear in mind that that proposal will not necessarily be the permanent one. It is just interim. And it's a good one because it means that you will still be able to be in touch with your child. And it's also an indication to the court that, hey, if there are allegations of like grave allegations, then why is the parent allowing the other one to spend time with the kids? So that could be interpreted that child protection is not necessarily a priority. So therefore, if you get offered to spend some time with your kids, then absolutely do so. Either party may also be offered supervised contact, which has a bad reputation because it typically takes place every other week and it can be limited to just a couple of hours, whether it's 3 hours, 4, or even 2. But most importantly, it's inconvenient and expensive. And either party may also be offered supervised contact, which has a bad reputation because it can be expensive and it might only take place a couple of times in a month. And it might also not be a natural place for you to spend time with your children, but in some cases it might be necessary if the child is a newborn, or if you have never had any contact with the child, or if there's allegations of abuse where there's like a heightened risk. However, one potential positive of supervised contact is a report that's written after each session. And that report can be used in court as supporting evidence of the relationship between you and your child. And there will be evidence by a third party, a social worker, which is great because it's an impartial witness. And in the court proceeding, the court puts heavy weighting towards observed relationship between a child and a parent rather than what's spoken by each parent or what's spoken by a child. So like, therefore, if an allegation might be that the child does not want to spend any time with you, doesn't like you, but then there's a report from a social worker that actually shows that you and your child have a great relationship together, really affectionate, and you play together, then that can help support your counter arguments. One of the potential benefits of supervised contact is that at the end of each session, both parties in the court will receive a report on the session. And that is good because that's done by a social worker. And it means that if there are allegations that your child does not want to spend time with you or doesn't like you, or that you are not an engaging parent, then you have potentially a report that can be used to counter some of those allegations. During your journey, you are likely to interact with Cafcass. They are the Children and Family Court Support Service, and they represent children's interest in family court proceedings. And this goes back to what I mentioned earlier, that the court in Cafcass, they represent the children's interest, not your interest. And one thing that Cafcass carries out first is a safeguarding check. Cafcass carry out a safeguarding check in the capacity of a third party. They are not employed by the court. They are doing this entirely as third parties to help the court get a better understanding of a child and their lives. Because once you start the court proceedings, the judge or the court don't know anything about you except what's included in your statement. And therefore, Cafcass is then used as a third party to gather basic information about like whether you have any criminal convictions, your history with the police, any information from local authority or local councils. And they would also speak to both parents to learn more about you and also understand more about a child's circumstances. And then they put all of this together as a summarized report for the police. And bear in mind that this is just a reporting by Cafcass. They are just like not rehashing, but they're sharing and summarizing what they've gathered from you parents and also from other third parties. What's in the report isn't necessarily facts. It's not necessarily everything that a judge should take into consideration. And some of it might potentially be incorrect as well if it's mentioned by the other party and it's a bit incomplete. And Cafcass, they don't determine evidence. So therefore, they will not be able to verify or validate anything that you tell them is true. They are just gathering information from third parties and providing that to the court. However, Cafcass will also be interested in just speaking to you, like understanding the relationship between you and your child, your current living arrangement. So speak as frankly as possible and be child focused. Speak more about you and your child, and don't focus too much on speaking about the child's other parent. And of course, if there are things that are relevant with regards to allegations, then please share those with Cafcass as well. Before the call, they will likely have radio statements as well, but they will also want to gather first-hand information from yourself. So be very consistent because they will write down what you say. Not everything you say will be included in the report, but make sure that your story is consistent with what you wrote in your first statement. The call with Cafcass can last 40 minutes, it can be 60 minutes, it can even be 70 minutes, depending on the complexity of the case. But be as relaxed as possible and bear in mind that it's only the beginning of the journey and nothing that's written down or said in the beginning will be decisive to the final outcome. So be relaxed. If there are allegations of abuse or incidents that are heavily contested by either party, the court might order a fact-finding hearing. And this could be a fact-finding hearing that either hears only allegation from one side, or it could be a proceeding that hears allegations from both sides. And to keep it simple, I might have a couple of allegations, and then the court basically orders that I put together a Scott schedule, which is a table. And in the table, they might say that I'm limited to 3 allegations or even 14. So I table each allegation and write about the actual incident and also what abuse I believe took place. And then the other party has an opportunity to then respond to all those allegations in the table and also in an accompanying statement. And then subsequently, there would be a fact-finding hearing taking place. And this is the type of hearing that people can be quite nervous about because it involves cross-examination. However, it's one of the few types of hearings that includes cross-examination, and usually if there will be cross-examination at a hearing, a judge will make that clear. They will make it clear. So you will never be caught off guard where you attend a hearing and you get drilled with questions either from the other party or from the court, because ultimately they want the experience to be as least damaging to the relationship between both parents and also to each parent on an individual basis. Therefore, they refrain from ordering fact-finding hearings. This is important to know about because fact-finding hearings can take months to schedule. Like we're not talking 3 months or 6 months, even 10 months, or even potentially 14 months if there's a long table of allegations. And this period, of course, hampers progress It disables you and your children from getting closure and from moving forward as well. So therefore, the court tries to only order fact-finding hearings if it's 100% necessary. And during fact-finding hearings, you learn how nuanced the English language is, because it then truly becomes a word of words. Like, if you're the one making allegations, try to keep the allegations as focused as possible and try to focus on the ones that are about abuse rather than disagreements or bickering between parents, because the court is not interested in them. They're interested in allegations that are related to the safety or well-being of a child or indirectly through one of the parents. So try to think about all the allegations that you have and really put down the ones where you feel like it would make a big difference to you to have a judgment that is essentially in your favor. But do bear in mind that with some allegations, even if they are proven, they might not be relevant to the future arrangements for a child, especially if the allegations are related to something that maybe took place many, many years ago, but that behavior hasn't been repeated since and things have been resolved. But even then, it's still good to put the allegations down, because it also important for the other person to understand what is abuse and what isn't. And try to be specific about each incident and the type of abuse it is. Is it physical? Is it emotional? If so, why? There's lots of sites where you can look up the definition of abuse and how to contextualize it in your allegations. As always, any evidence that you have, please reference it in the appendix. It's not strictly necessary, but it substantially helps. And if you are responding to a Scott schedule, read all the allegations carefully and also consider them. Consider whether you've made mistakes in the past, whether there's behavior that you engaged in the past that you shouldn't repeat again. So have proper self-reflection, because the court process is for the benefit of all parties involved, especially the children. So do strongly consider the allegations that have been written. Unfortunately, the allegations that are made against you, they are the only ones that will be heard during the fact-finding hearing. So therefore, you cannot counter that with your own allegations. The only way you'll be able to do that is if the judge has also asked you to produce a Scott schedule of your own allegations. So the allegations are super focused on just the ones that are in the Scott schedule. And one thing to do is to read all the allegations carefully and also look at the evidence and look for things such as incomplete evidence, or whether an incident has been described in a way that contradicts with your view. So feel free to put forward your alternative version as well, but also feel free to show a bit of remorse as well, where if there might have been an incident where something took place that maybe shouldn't, show that you understand that those behaviors shouldn't be repeated, and maybe even share things and steps that you've taken since to improve yourself as a person. During fact-finding hearing, you'll go through every allegation one by one. You'll go through one allegation, and then there would be opportunities for both sides to cross-examine each other. And one approach to consider is to have the Scott schedule and your statements there with you and refer to them. Feel free to take your time when replying to answers. If you feel that you need to have a look at your statement or the Scott schedule, then you're free to do so as well. One thing to potentially consider is to say as little as possible, because if you potentially start speaking too much, you might stumble on your words or contradict what you've said. So try to answer questions as precisely as possible and avoid deviating too much towards tangents. And that will basically minimize the risk of what you're saying being misinterpreted by a judge or the other part or the other party. Witnesses are permitted. However, the court needs to be formally notified of their participation, and the same applies to the other party. They need to be notified as well, and the witnesses will have an opportunity to submit their statements ahead of the hearing. And also during the hearing, there will be an opportunity to invite the witnesses to take part and also to be cross-examined by the other party and also by the judge as well. And on the last part, the judge will likely take part in cross-examination themselves, especially since it's a fact-finding hearing and their job is to find out facts related to certain allegations. So you might find that they ask both parties some difficult questions just to eke out key facts and ensure that the hearing is productive. So how long will a fact-finding hearing last? That entirely depends on the number of allegations and the number of witnesses involved. It can last a whole day from 10 a.m. to 4 p.m., but it can also be spread across a number of days with start and stop in between as well. It can greatly vary. It can genuinely vary, and it's really tense as well. During fact-finding hearings, don't be pressured into giving answers to questions that you either don't understand or questions that are about incidents that you don't fully remember. So if you don't understand a question, feel free to ask for the question to be rephrased, or feel free for the question to be broken down into two if you feel like it's a question that's asking a couple of different things. So always when you're asked a question, think about like, what's the intention of the person who's asking it? And if they're asking for a yes or no question, feel free to caveat that if necessary. You will potentially be asked about incidents that took place 2 years ago, 3 years ago, 5 years ago, or 10 years ago. It might even be difficult to recall what you ate on Tuesday last week, let alone someone asking you about something that took place many years back. And therefore, if you feel like you genuinely don't recall all of an event or some of the details in there, feel free to say so. And also make sure that the other party or the legal team doesn't almost like shoehorn you into giving certain answers to questions that they ask, because they will aim to essentially make you answer questions in a way that prove the allegations. And this is not necessarily a criticism, but that's just how court proceedings work. Like you're at two opposite ends. You want to prove one thing and the other party want to prove something else. And that is not necessarily criticism. That's just how court proceedings work. You have one party and then you have the other party, and they both have slightly different aims. And therefore, the other party could potentially try to put words in your mouth by making statements that are rephrased as questions. And if you don't agree with them, do make that explicitly clear. You can say, I disagree with that question, or that statement is not my opinion, or something else. So do make sure that if you don't agree with something, that you make it explicitly clear, because the judge will pick up on this. They will pick up on whether you agree with something or whether you contest something. So if you don't contest a certain statement, then that could be interpreted that you are accepting of that. So do make sure that your position is heard clearly, both in your written statement, but also during the fact-finding hearing. After cross-examination, both parties will have an opportunity to verbally share their closing remarks, and the judge will write all of that down. And there afterwards, there'll be a break, and during this break, the judge will write the judgment. And this could be handed down on the same day, within a couple of hours, or it could take to the next day or 2-3 days later, depending on the complexity of the case. And the judgment will be a long document, typically several pages long. And in there, the judge will read the judgment to both parties. And in there, they will make it clear for each allegation, which allegation is proven. And they will also speak how they came to that conclusion. But the judgment will also include other statements about what the judge think of both you parties and also the child, in relation to maybe your parental capacity, your feelings and emotions during certain incidents, some of which you might agree with, other which you might not agree with. But the most important thing when receiving the judgment is to look at the bigger picture. And the bigger picture will be about whether the allegations are proven or not. And it would also be about whether the allegations are relevant. And lastly, to which extent that they are relevant. Therefore, there might be allegations that are proven, but they are not relevant to the future arrangements of a child. Nevertheless, they're still important, especially if they concern behavior that could be a risk to the child, yourself, or someone else. In that case, it's important for the other person to really understand that. If you don't agree with the judgment, you have 7 days to appeal it. And in order for your appeal to be successful, you need to prove that the judge reads the conclusion. You won't just receive the judgment verbally, but you will also receive a written copy of it. If you disagree with the judgment, you have 7 days to notify the court that you would like to appeal the judgment. And in order for your appeal to be successful, you need to highlight that there's been a failure in the proceedings, or that the judge has reached the wrong conclusion by either ignoring important facts, giving incorrect weighting to certain facts, or take into account information that is not factual. So it can't just be a case of appealing because you disagree. But the grounds for it to be successful need to be that the judge reached the conclusion incorrectly. However, it needs to be incorrectly using the information provided. And by incorrectly, I mean incorrectly using the information that the judge had access to. So this is why it's important to put a lot of efforts into your statements, because the judge will generally make the conclusion using what's been written. They will take into account what you've said, but what you've written is really important. So therefore, if you haven't submitted specific information that might have been important, then you can't claim that the judge has reached an incorrect conclusion. So you should always include as much as possible and reference facts, because that is what the judge will go by. So therefore, your appeal cannot bring forward any new information, but the appeal needs to be based on everything that has been submitted by you and the other party. If the appeal is successful, there could be a new fact-finding heard by a higher level judge, or the judgment could be set aside, which means that it's technically cancelled, and then the judge can propose next steps, basically. If the 7-day period passes and there's not been an appeal, or an appeal has not been successful, it means that what's contained in the judgment becomes facts. So therefore, if you have been accused of neglect, but the judgment said that you've not committed neglect, then that's going to be the basis of recommendations made going forward that you have not committed neglect. And also similarly, if you have been found to carry out physical abuse, then the basis becomes that you have carried out physical abuse. So everything in the judgment becomes facts, and that's why fact finding is important. But also the plus side is once you have a judgment, it also clears the air, it clears ambiguity with regards to the safety of a child or their well-being and accusations as well. And it means that you've significantly narrowed the issues that you disagree on, because once a judgment has been made on something, then those topics are not necessarily something that can be contested in other statements, because it's essentially facts. With the judgment, the court might also give directions on the next steps, and that could be a Section 7 report or other reports that are carried out either by local authority or by Cafcass. If it's a Cafcass Section 7 report, Cafcass might speak to your children, and they might also visit your home to observe you and your children playing together and socializing together as well. And they will likely speak to the children's educational provider, whether that's a nursery, preschool, or school, or even college. So they will try to gather additional information and speak to the people that the kids basically interact with on a daily basis, whether it's yourself, a guardian, school, or even a medical profession. And once again, Cafcass will also speak to yourself to get an update from both parents on how they feel and how things are progressing with regards with the child, or yourselves have any circumstances changed with regards to the child's education, where both parents live, and whether the child is seeing both parents and how all of that is going. And Cafcass will also again ask about the relationship between you two as parents. Have you been able to talk? Have you come to an agreement about something? Are there any commonalities between what you're both are proposing for future contact? Because ultimately Cafcass and also the court prefers there to be proposals from both parents jointly, rather than Cafcass themselves just like proposing something that might not be 100% fit for either the child or the child's relationship with both parents. Depending on a child's age or mental capacity, they may or may not speak with the child, but they will ask all sorts of questions about a child, how the child is feeling, and also their relationship with important people in their life. But they do everything in a nice way, indirectly, without causing harm, and they just let the child lead the way. So that is also something to be prepared for, because the child might say something about you that you don't expect, or something that might not be true, or might be correct but not entirely true. So it is definitely something to think about, whether or not you want your child to go through a Section 7 report. But it is also a wonderful way of like hearing about what your child thinks and what's on their mind as well. And everything that Cafcass gathers for the Section 7 report will be put into a report that's shared with the court and also with both parties. And within that, there will be proposal for future contact. Again, it's not a recommendation, it's a proposal to both parents rather than a recommendation for the court to enforce. So both parents will see the proposal, and there'll be a period during the parents will have an opportunity to consider the proposal and also perhaps speak amongst themselves to see whether they agree with it, or whether there are parts that they don't agree with but can resolve. And that means that when you come to the dispute resolution appointment that comes after the Section 7 report, then you will hopefully have narrowed down the issues, which are basically another word for things that you don't agree with. And these could be big things, whether it's how to split the summer holidays, or where a child should live, or which school a child should go to, for example. So dispute resolution appointment is hopefully, like a place where those issues have been narrowed down. However, at dispute resolution appointment, you are under no obligation to agree to what the other person proposes. Most importantly, at the dispute resolution appointment, you have an opportunity to contest Cafcass' proposal, and you can let the court know, or the other party, what you don't agree with and why. And the judge will potentially help try to resolve those things for you at the particular hearing. But if both parents can't come to an agreement, then the judge will order a final hearing. The final hearing should be the final hearing of your case. So this is the last opportunity to address the court and re-emphasize your proposal for future contact. But most importantly, it's an opportunity to highlight why you disagree with Cafcass. Usually the court will strongly follow Cafcass' recommendations or proposal, unless Cafcass has formulated those incorrectly, or if there's been a change in circumstances since the Section 7 report was carried out. Because bear in mind that there can be many months of separation between each step in the court proceedings. So it could be that when the Section 7 report was carried out, you might not have had a home, and then now you have a home with a bedroom for your child, and therefore you are now able to have them overnight, for example. So the final hearing is also an opportunity for that, to share any changes in circumstances, either with regards to the child, your work, where you live, and also anything else that may have happened between you parents or between you and a child. And therefore, similar with the statement for the first hearing, you should include as much as possible, because now this is your final chance. And if there is an outcome where the judge makes a recommendation that you don't agree with, you will have the opportunity to apply. If I remember correctly, you have 21 days, but that application for appeal can only be successful if the judge has come to the wrong conclusion based on the facts and information that have been provided. So you can't file an appeal and include new evidence or new witnesses that were not part of the proceedings. So do put as much effort into the statements for the final hearing as possible, because it is an extremely important one. The duration of the final hearing can vary. It can be as short as 3 hours, but it can also be 6 hours. It can also take place over a couple of days. It depends on whether any witnesses need to be part of the proceedings, or if there or whether there's cross-examination. Usually there's not cross-examination, and the judge will try to avoid cross-examination taking place, but there could be. And that might mean that a final hearing could stretch over a couple of days. It all depends on how simple your case is versus how complex it is. At the start of the final hearing, the judge will rehash things that you agree on, and then the judge would also summarize the points that you don't agree on, and then during the hearing you'll go through each of the outstanding issues bit by bit, and you'll both have opportunities to voice your opinions and thoughts on it. And also the judge will also have an opportunity to ask either of you questions. And then at the end, for the issues where you both disagree but both of you have recommendations, the judge may also listen to Cafcass, who might be invited to attend the final hearing. And then at the very end of it, on the bits that you don't agree on, the judge will basically give their recommendations on what they believe is right, and that will form part of the order. And that will basically be it. If you disagree on it, you can appeal it. If you agree with it, then that's absolutely fine. But once the appeal period ends, so that is basically the end of your case, and the only way to return before a judge is to file another application. So it is very important to put as much effort into the court proceedings as possible, because once the final hearing ends and the appeal window closes, then that's what you're stuck with, really. And that's what you may even be stuck with for years, because even if you go back to court, the court will only change the child arrangements if it's in the best interest of a child. They won't do so because parents want to or parents agree. And it could also be a case that you go back to court and you ask for more time, but actually what you end up getting is less time. So there is that risk of potentially getting less time with the child if you go back to court and circumstances have changed, but they've changed in a way that disadvantages you. Hopefully this has been useful insight into family court proceedings. The most important thing is to be child focused and focus as much energy as possible on creating a great life for you and your child. And by great life, I mean giving the kids as much of your attention as time. I hope that this has been some useful insight into family court proceedings. The most important thing is to be child focused and focus your energy on creating a happy life for you and your child. And that happiness will come from you spending quality time with your child rather than maximum quantity of time, because you can still live a very happy life with your child even if you don't see them every single day. And what they will remember more than anything is less about the number of days that you see them in a year, but more about what you do with them. And also during the period when you're not with them, you have a lot of headspace to plan fun weekend activities and getting the house in order, sorting out laundry or washing, or even taking up a hobby. Overall, it's a mentally exhaustive and emotionally stressful journey that can take unexpected twists and turns, some for the better and some for the worse. But it's also a journey that once it's come to an end, there is no confetti, there's no one outside giving you balloons, giving you flowers, etc. And you're also then potentially left with having to then replace all of this energy and time that you've devoted towards conflict to then fill that void with something else. And that can also be like a huge change. But after a couple of months, you should have been able to reset your emotional and your mental balance as well and get back to being yourself or becoming a better person. So it will definitely get better, and it's one of those experiences that unless you've been through it, you won't fully understand it. But it does get a lot better. And also once it's come to an end, there is a sense that you need to reconcile with the fact that you now have a co-parent, someone who you need to work with potentially for the rest of your life. Because if you have children in common, children will always have their parents as long as both parents are alive, like they will always be there. So you might still need to collaborate or communicate in one form or another. And that's when you need to be able to set aside conflict and ill feelings that you might have for each other and just be very professional. And in general, things can get worse, but they can also get a lot better. Because as I mentioned earlier, I think 70 or 80% of applications for child arrangement orders do not go to a final hearing. that is because parents eventually decide to agree something between themselves. So no matter how bad or how difficult you think your situation is, it can definitely get better. But also in some cases, it rightfully can never get better. But at least it's worth to give it a try where you can to reach an amicable solution as quickly as possible.